Hey, how you doing? It's time for another exciting video. It is an exciting video, but it's a smelly video. Hi, I'm Brian Parker, and this is the takedown and the breakdown. Today we're mining for title gold. You're going to be seeking some smelly SOCS. What do I mean by that? Well, I guess we'll find out. Stay tuned. If you hate the smell of dirty SOCS, like, love, subscribe to this channel. You're going to have some fun today. This may be a long one and in some cases boring, but I always give you that warning and hope that you subscribe and love us anyway. Get this out of the way. Please go to our membership website, collectionstoppersolutions.com. Ton of stuff, including dirty SOCS, and it just is increasing, improving every day. Our great webmaster Natalie is adding to it as we speak. If you give us a comment and say, hey, what's up with this? We'll fix that. Or hey, how about a video? I'll do it. So this is a breakdown of I'll give you, get a load of this title name. Breaking down a broken chain of title from Spring Oaks Capital SPV, LLC, and Smelly SOCS. Yeah, that's how I've started the video. So this is another lesson today on how to handle chain of title cases, which mostly are all those cases. Oh, I'm giving a shout out for my friend here who is a guitar teacher, Chris. And that's his business. I don't know if that shows, but he's gave me a great free shirt. So we're breaking down the pleadings today. And that's what we do first. So you know, if you've heard from me enough and I've bored the hell out of you, the only thing that hopefully you remember is we take their documents and what do we use? What do we do with those documents? Hello? Beulah? Voodoo? That's right. We use their documents against them, and that is in the form of a counter affidavit. So when I do these videos, this one will be a long one, keep the counter affidavit in mind because this is where it's all going. So let's first look at the lawsuit. Here's Shazam, Cindy, and that is 2 pages of the lawsuit. And what you do is, the first thing you do is you break down the lawsuit. And what you're really looking for is a linchpin. A linchpin is something, or a hat holder, that you're saying, in this case, they're making 12 allegations. What's the thing that proves, at least to them, that they own the debt and you are going to lose? Surprisingly, it's a very low percentage. In this case, meaning of all the pleadings, there's only 1 or 2 things that actually make their case for them. Here, Cindy emphasized number, paragraph, pleading 6, Shazam. And so I'll read that for you. That on or about April 19, 2022, the account at issue was transferred, sold, or assigned from First National Bank of Omaha to Plaintiff. And here's how they support this. See attached bill of sale. So up to that point, you've just got flowery language, say we are who we are, we're from here, you're from there. And then more vague stuff, but this is the linchpin of their case. So when you break these pleadings down of the lawsuit against you, get over, have your 5-minute pity party and go, all right, let me see what they got. Their whole thing rests on 6. They're saying, and by the way, first up, if you own something, do I need to say I purchased, leased, was assigned, had transferred to me? Go, I own this, you owe me, right? But they write the issue, the account at issue. It's not even a debt, it's the account at issue. Which, by the way, there's nothing at issue until there's a lawsuit at issue. Transferred, sold, and or assigned. Why, if you own it, do you mess with yourself like this? And you say, see the attached bill of sale. So again, the linchpin of 12, 15, 20 pleadings. Pleadings are each paragraph. You are this, we are that, you contracted, you signed, you owe us. Those are all pleadings, but there has to be something that proves you owe the debt to them with their proof that they own it. So this is title gold. Title gold, Jerry. It's gold, Jerry. Meaning their broken title history is right where they say, and they claim they own the debt. So look at this. This is a nugget. This is title gold. So the first thing I said to you is, did they transfer it, buy it, assign it, or they sold it? You know what you did if you did it. And if you didn't, you throw a certain bunch of words in there just to get, hopefully, your default, and you can say to the judge, see, we own it. So that's number one nugget, is their use of flowery, ambiguous language. Number two, they are claiming that the creditor, First National Bank, did something, assigned blah, 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 to plaintiff. Go to the bill of sale. So let's do it. Shazam, Cindy, with the bill of sale. Shazam. Let's look at that lovely, lovely. Why is it lovely? Because it's going to win the case for you. So first of all, the first thing we notice is the plaintiff in this case is, I mean, you're going to find out why it's Smelly SOCS. Spring Oaks Capital SPV LLC. All right? No, it isn't. It's Spring Oaks Capital. Yeah, well, it is, but it isn't. But it's Spring Oaks Capital SPV LLC. This video is going bad. So look in the bill of sale, and you can see right in the bill of sale, no, it isn't. There's a company, Spring Oaks Capital LLC. So first of all, the SPV means it's a separate corporation. It's a different name. And one of the things you do, the voodoo that I do, that you may want to do, is you just go to the corporate search database for, in this case, it's Delaware. So we found out, let me put it up there, Cindy, the ID number 802-403-974, Shazam. So that's Spring Oaks Capital LLC. It's a separate corporation, right? And it's a limited liability company. Cindy, have this up there, state of Delaware. So now you go to the state of Delaware. It's easy peasy. And put up, Cindy, the state of Delaware search for the Spring Oaks Capital SPV LLC. Shazam. And you can see that's a separate entity, right? So the plaintiff, the paragraph 6 says was assigned the debt from First National Bank, is, just call them SPV or SOCS, SOCS. Spring Oaks Capital SPV. I called them SOCS. I got to do that so you remember. So that isn't in, put up the bill of sale, Shazam. It's nowhere to be found, but they specifically say at paragraph 6, just see the bill of sale. Well, the plaintiff's not in that bill of sale. End of case. So let's fish around and get some good stuff for us. This bill of sale was signed the 20th and the 21st of April 2022. It also refers to receivables and accounts. It actually says receivables to the extent that we own. So they can't even nail the substitute language of debt. They should say receivables, but instead they say receivables to the extent that we own it. Let's, if we can emphasize that, Cindy, for people to see I'm not full of crap. Look at the fourth line up on the paragraph, just to blow it up there. And there it says, and to the extent of seller's ownership. Who's the seller here? It's First National Bank of Omaha, and the buyer in this case is Spring Oaks Capital, separate from the Spring Oaks Capital SPV. So that supporting document actually hurts them with the linchpin that all they have to prove that you owe them the debt that they own just went away. Nugget number 3, there's no mention of SOCS, S-O-C-S, in the bill of sale, okay? But watch out. They will try to, hey, Judge, see, we own it, SOCS. That's why you got to write SOCS. Why do I do SOCS, by the way? First of all, I have a weird sense of humor. But SOCS is the plaintiff. For example, and this is just for fun, when I do Capital 1 cases, it's Cap 1 or Capone. which is, I guess, a Chicago gangster from the 30s. But that'll litter the whole answer and everything. Capone, Capone, Capone. It's just another thing that I do just to keep the emphasis on what they did wrong. It's fun, you don't have to do it. Look at their caption of their lawsuit, Shazam, and you will see it's Spring Oaks Capital SPV. Nowhere is that company in the bill of sale that they say proves they own the debt. So again, one of the nuggets is you break down corporate identifications so that they can't fudge. You got to worry about that they fudge and say, well, yeah, it kind of has the same name, Your Honor. Yeah, right. So let's look for more breakdown gold, Jerry, gold. Okay, so there's in the bill of sale, let's break that down just a little bit more, and I'll put up a list. Cindy, put up this list. Number one, no mention of the word debt, just accounts receivable to the extent of seller's ownership, no mention of the name of anyone or the specific name of you or your client and the account number. They say there's a receivables data file attached. There isn't. There is an assignment attached. And I know they're going to go in on saying, look, we were assigned the debt, but the bill of sale has to refer to the assignment, and all it refers to is the receivables data file. A receivables data file is not an assignment. And then the assignment that was attached to the lawsuit is not mentioned anywhere, either in the lawsuit and not in the bill of sale, as they said. They just rely upon the bill of sale to their own detriment. Again, put it up again, number 6, Cindy, the linchpin of their ownership proof, Shazam. And again, this might make a lot more sense. First National Bank of Omaha, which is the original creditor, is selling it to Plaintiff. That's SOCS. See the attached bill of sale. There are no SOCS, clean or otherwise, in the bill of sale. So let's look at their assignment, give them a fair day, but what's the point? Put up the assignment, Cindy, Shazam, at least what I've given you. Look at the cutoff date of the receivables. It's March 31st, 2022. Well, what's that got to do with the bill of sale? Because that ends on the 20th of April. And the assignment is at the very top of the words assignment are dated as of April 19th. So your debt is not inside this bill of sale or anywhere else without your name, without the account number. And now they've made it easier for you by saying everything we put into this bill of sale or assignment, the cutoff was March 31st, 2022. So again, more of a plate of wrong. And remember, when on the bill of sale this was signed, put up the bill of sale signature, Cindy, Shazam. See, somebody from First National Bank and somebody from First National Bank is signing on the 20th and 21st of April 2022, well after their cutoff date. And they're saying in a later data form, this stuff went over to these guys. Just trust us on this. There's a lot of contradictory information. There's no proof that your debt or the debtor's debt was transferred. So, do they have anything else in their pleadings? They have one more thing. Go to paragraph 11, Cindy, and there you can see proof that my client owns it. No, it isn't. By the way, this case is, again, one of my client's cases that I just worked on. One of my goals is to have you have real cases that I work on so you can transfer not just in a case where there's dirty socks, but also with UHG or Midland Credit or PRA or Crown Asset Management or LVNV funding. Why? All this stuff applies. You know what I'm going to do? I'm going to do a course on this. So that's upcoming. I'm going to do a course on what to do in court, what to do with the pleadings, how to break down a dirty chain of title, if you will, or a broken chain of title, how to handle litigation. I'm going to do a quick course for you. Excuse me if I get my breath. But back to pleading 11, they're saying the statement of the account and an affidavit verifying the account is attached to this complaint. See attached exhibit. So let's look at it. Let's go. Hot off the presses. Cindy put up their affidavit of account, and that proves that the debt was assigned from, there's nobody mentioned. This is the thing that Michigan requires, and so do other court states, that if you don't have the contract, then you have to have a substitute. You have to add an affidavit. That's why we call our affidavit a counter affidavit, all right? So there is no mention here of there being anything assigned to anybody. What they do say is, put up paragraph 2 of the account stated affidavit. Their ordinary course of business, plaintiff regularly purchased contracts from the original creditor or the assignees. If you know something to be true, wouldn't you put it in an affidavit? Also, put up number 4, Cindy, Shazam. That he or she, it's a she, when I say it's a she, meaning Miss Reeves, wouldn't she say I instead of he, she, makes this affidavit based upon plaintiff's books and or records. So when you claim to do an affidavit, you have to have personal knowledge. So they somehow find a way to put in the words personal knowledge. I don't think they did in this. Purchase makes it no. So their 803, this is all hearsay. So their 803.6 exception has to have something about personal knowledge, has to be, if there are documents relied upon, they have to attach to the affidavit. None of that exists here. But the affiant, Miss Reeves, is claiming she has personal knowledge, not personal, but she makes this affidavit based on plaintiff's books or records, her review. My question, if she is familiar with the books and records, why no mention of the original creditor or assignees if you are familiar with all this stuff? And look at, where is that? Cindy. Look at number 5. Put up number 5, Cindy, Shazam. The defendant is justly indebted. He's either indebted or he's not. I don't know what justly means, but again, they always use flowery language. To plaintiff in the amount of 23, blah, 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 including interest as of May 1st, 2024. All right, so why not May 1st, 2022, right after you supposedly purchased the debt? That's something you may want to ask. Also, they are signing this affidavit May 2024. So that means at least in Michigan and other states, within 10 days, you can file the lawsuit and use this affidavit. And as you can see, they did just, no, they didn't. Look at the summons. Shazam, July 25th, 2024, 2 months after the affidavit was signed, it was filed with the court. So the 10-day rule has just been crushed. But more importantly, if you can see, just put up the account stated affidavit, the whole thing again, Cindy, Shazam. Look what they did. This is not a wall, but it's a good brick. They named themselves plaintiff, and in this case, my client defendant, 2 months before that's possible. So had they sworn under oath, as they are claiming, they would be lying. But wait a minute, there's something I want to tell you about that. When you create an affidavit, and I do this all day long, you have to say the following. Being duly sworn and upon oath, you verify, certify, and under penalty of perjury, you declare as follows. So that must be in the language for you to have properly signed something under oath. So Cindy, if it's not up there, keep it up there. And you can see that she did oh no, she didn't. She has not the words under penalty of perjury. It's significant because if she has not told the truth, then she kind of didn't do it under oath. But wait a minute, isn't there a notary making this all under oath? Let's take a look. No, it isn't. The notary is just saying, if we can, Cindy, emphasize on what the notary is saying. Just emphasize that. Shazam, sworn to or affirmed and subscribed to me before this, blah, 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 by Michaela Reeves. So she swore that that was her. That's it. She hasn't saying that all the stuff was true or anything like that. In Virginia, this is a Michigan case. So when you get an affidavit, one of the analysis I want you to use is to Google the affiant. Look for a signature. Why? I did a lot of robo-signing. I'll just leave it at that. You take the person that's signing, go look at LinkedIn, Google, just find signatures and compare. You'll get lucky sometimes. Check out, as they say, she says she's an agent for Plaintiff SOCS. I bet she's not. I see a lot of times where they say they're agent for a particular plaintiff, and it turns out they're an agent for a holding company or a separate company. And in this case, you may want to check that out in your affidavits. Check out the notary. I've caught notaries that have signed something as under oath and found out they lost their membership a while back. I've seen that, especially in the foreclosure days. In the federal, I know you're asking for this, snooze alert. Here's how a affidavit is to be signed at least in federal court, which permeates down to state courts. It is well established that an affidavit is required to be sworn to by the affiant in front of an officer authorized to administer oaths. Alternately, under 28 U.S.C. 1746, when I have my client sign, and this started in COVID, where I didn't want them going to a shop and getting COVID from the notary, I'd say, well, let's do this under federal law. You must say, declarations may take the place of affidavits so long as those declarations are made under penalty of perjury. Certified and correct, dated and signed. So she has not sworn under penalty of perjury. Therefore, at a very minimum, her affidavit is hearsay, and therefore it doesn't meet the exclusion of 8036 or any other state or federal rule to come in as an exception to hearsay. So that's gone. And boy, they don't want that in anyway because it smells like socks. It's really bad. So that's off with the head of the affidavit account, but it's not signed under oath under penalty of perjury. So what is all this? This again is a law firm and a debt buyer using pretzel litigation to make up for the securitization of all. When you securitize debts, which most, especially Bank of Omaha has done, you send them off into different places and you get money back, and it's in different tranches. And check this out. This is why you break down the pleadings and the accounts. They actually say in their Schedule A, let me put this up there, Cindy, Shazam, First National Bank of Omaha funding portfolio, funding, April 2022, tranche. What is a tranche? I will tell you right now. Tranches are segments created from a pool of securities, usually debt instruments such as bonds or mortgages. Tranche is a French word meaning slice or portion. They are commonly found in mortgage-backed securities or asset-backed securities. So clearly, even First National Bank of Omaha is admitting this is in a securitized deal. I want to caution you, and I have calls and emails about this. Stop looking at securitization if you have a debt buyer case. That stuff is irrelevant to whether they own it. It is an analysis that how can they have purchased it from, in this case, National Bank of Omaha, if it was sold to a securitized trust. That is a truthful, relevant analysis, but you can focus in on the real documents of it all. If you're going to use securitization, use it in credit cases because it's an eye blower for a judge. You can add to it, like they gave this to me by saying it's in a tranche, which is language of securitization. It's the only time you're going to see that. Then I will use it. But generally, don't focus on securitization in a large way when you're doing debt buyer cases. So you take all this, and what do you do with all this? You put it in your counter affidavit. That's countering their affidavit. You plunk that, see my video on plunking, into your answer. See my videos all on how to do an answer. Free PDFs on how to do answers. Here's some videos on counter affidavits, and that goes into a counterclaim or an affirmative defenses. And all you've done, all this work is put into your counter affidavit, which will follow you the whole way through the litigation. It fits into every hole and circumstances, generally. You can even take it with you when you first make an appearance to court, because it's your whole case there. So at the end, all this, I plunk into my counter affidavit, which is plunked into my answer, which is plunked into my affirmative defenses, and if they don't follow what I tell them to do, plunked into my counterclaim. So I'm going to give you, attached to this video on my membership site will be the following things. Cindy, put up everything we're attaching. Thank you, Shazam, including the answer, the counter affidavit for your Word template use, a number of other things, including this, another snarky email alert. Good afternoon, guys, I wrote to the law firm. This is another debt buyer purchasing debt without proper proof and using pretzel litigation to make sense of a debt that was securitized by the creditor prior to the sale of any receivables or accounts. You can just refer to your paragraph 6, the first of many problems of proof of ownership. Remember we went over paragraph 6? The bill of sale is signed April 20th and 21st by First National Bank. Michigan law requires the signer be the new owner or assignee. I didn't throw that in because this is a general video, but I threw that in my Michigan case. Paragraph 6 is false. Your client's assignment, in quotations, has a date of April 19th, 2 days earlier than the bill of sale, which would be impossible for Spring Oaks Capital LLC, as it did not own anything. And no mention of my client's debt in the bill of sale. The affidavit signed under oath claims SOCS is a plaintiff and my client is a defendant months before the lawsuit is filed. There's no mention or how or when SOCS obtained the debt in your affidavit. They created the affidavit, they can put wherever they want it, and they chose to exclude the ownership. And now I'm going against what I told you, but they also excluded any mention of securitization. Use that in every affidavit. I don't care if the debt buyer case or a creditor case. They have mentioned nothing about securitization, especially when you have proof, which I have on National Bank of Omaha. It's easy to obtain. There's no contract attached. So why is an affidavit attached to a lawsuit against you? Because there's no contract attached. But they say you violated the terms and conditions of a contract. Well, where's the contract? Also, I didn't mention this, but you got to ask for that forward flow agreement. The bill of sale specifically says, for value received, and I'm reading this, and further consideration of mutual covenants, blah, 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 and conditions set forth in the, and they call it forward flow debt sale agreement, the agreement. So you want that, and you ask them for it, and you'll settle this case. So there's no chain of title, lawyers. This is all pretzel litigation. It really is. So your client's case is a whole plate of wrong and no ownership to have standing or bad documentation. Appropriately, please accept a mutual walkabout in the case and debt by September 30th to avoid a counterclaim. I've attached that email to the video on the membership site so you can use it the way you want to, but my advice is don't say anything unless you're going to do it. When you answer a lawsuit, as I frequently tell you, you continue negotiations to settle the debt, but you say to them, in 15 days, I'm going to answer this if you don't settle this. Never threaten something unless you're going to follow through. So I'm going to follow through with this video, placing it on my membership website, along with all the templates for you to use and a PDF of the actual lawsuit and my answer, my counterclaim, all this good stuff you need to do a debt buyer case, or if the debt buyer has dirty socks. I think you'll agree the socks in this case don't smell so good, but you're gonna do great. Thanks, Chris, for the free shirt. Chris Guitar is my buddy Chris Guitar. And go to our membership website, like, love, and subscribe. And I hope this was helpful. Thank you very much. Bye-bye.